Hi, I'm Joel Weissler. I'm an attorney, a lawyer, practicing since 1989 in San Diego County, California. It's amazing how many people ask me under what circumstances do they need to update or create estate plans. One common misconception about estate planning is that once you create a will, trust, or other estate planning documents, you are set for the rest of your life. Unfortunately, this is not true. Your documents are not a one-and-done thing. Rather, they will have to be updated as your life and the law changes through the years. There are at least 7 life changes that signal that we should update our plans, wills, and trusts. Some of the life changes that warrant an update to your plan are fairly obvious, but they can still be overlooked. For example, few people, when sleep deprived after the arrival of a new baby, would think, hey, I should call my estate planning lawyer. But that is exactly the right time to ensure your documents reflect the birth or adoption of your new child. Leaving out a child can distort your existing plan in ways with which you just wouldn't expect. As a general rule of thumb, for updating documents, it's a good idea to keep in the back of your mind 7 major life changes that may warrant some changes to your plan. Here they are. First, marriage. The rules providing for when and what assets a spouse automatically inherits is seldom what people really want. In California, marriage also affects beneficiary designations, so they will need to be updated or reaffirmed. You may also want to move your new spouse into positions of legal and financial authority. Finally, marriage may open up income, estate, and property tax savings opportunities, which should be discussed with your attorney sooner rather than later. Number 2, divorce. The other side of the marriage coin also warrants estate changes. California makes some of those changes automatically, but they can be undone, or an argument can be raised that they weren't what you wanted if you don't formally make those changes at your first opportunity. If you still want your ex to serve as your executor or trustee over your children's trust when you're gone, you must reaffirm that appointment. On the other side, leaving your ex's name as a beneficiary of accounts or policies without reaffirming those designations is an invitation for trouble to be avoided. Number 3, perhaps you've been widowed. In that case, your beneficiaries will likely change, and you may have an inheritance from your spouse or powers under your spouse's estate plan that need to be incorporated into your own plan. Number 4, new children or grandchildren. There are other considerations if you have a new child or grandchild. Whether through birth or adoption, new family means new needs. You may want to create a college fund or set up a special trust. Furthermore, you'll want your estate planning lawyer to draw up legal guardianship nomination papers for your child, just in case something happens to you. 5, sometimes in our life, our financial situations change. You might get a new job, get a significant raise, or just receive some windfall. But this sort of situation calls you to review your estate plan and determine whether it provides properly for those changes. Don't forget that new jobs often mean changes in employer-provided life insurance. We regularly work with our clients to make certain that their work life insurance's death benefits integrate into their estate plans. Number 6, asset acquisition can also touch your plan in a way that requires updating. This is especially true of large purchases, such as real estate. If you finance the property, you will need to plan how to pay it off if you die and to whom you want to leave it. We can help you incorporate all of these things into your estate plan. Number 7, if you're the entrepreneurial sort, the beginning or end of a business should also signal a trip to your estate planning attorney's office for plenty of reasons. If you're a business owner, failing to properly provide for the handling of your business after you have passed may cost your families the majority of the value of what may be the largest or second largest of your assets. A little legal work now can save big headaches later. While these aren't the only events that should trigger a call or visit to your estate planning lawyer, these are 7 of the most important. Separate from these events, you should also periodically visit with your estate planning attorney to discuss potential upgrades to your documents, to handle your circumstances more smoothly. Fortunately, making these types of updates is much easier than initially learning about planning and setting up an initial plan. It is critical that when these types of events happen, you come and see an attorney to update your plan. Failing to update may cause your whole plan to fail. I hope that the information in this video helps you help yourself, your family, and others. My firm, the Weissler Law Group, is dedicated to helping families prepare for life cycle events, build and protect wealth. Our goal is to serve our clients throughout their lifetimes, to be their attorneys for life. We can be reached at 619-281-1888 or at 760-487-8180. You can also find out more on our website.